Hi everyone, welcome to PilieroMazza's webinar on SBA's final rules on limitations on subcontracting. Welcome to you all. I'm going to mention this a couple times throughout, but these slides are available now to you. They will be available on our website. The sessions being recorded will be posted on our YouTube channel, and we will be seeing the questions as they pop up. Due to the number of attendees, we may not be able to answer your questions as we go, but we will do our very best. My name is Megan Connor. I'm an associate at PilieroMazza. I work in the Government Contracts Group, and I'm joined with my colleague Katie Flood. Katie and I have, between us, I think, drafted and reviewed hundreds of teaming agreements and subcontracts for set-aside prime contracts. So this is definitely an area that we both are familiar with, and this new rule was very greatly anticipated by us and by our firm. So we're excited that you all can join us today. Just to give you a little background on both of us, some of the things that we work on. Katie has counseled large businesses on their small business subcontracting plans. She's also very familiar with the hub zone regulations and that certification process. I've worked with various women-owned small businesses as well as the firms owned by ANCs and by tribes. So we've done a little bit of work, or a lot of bit of work, in the small business government contracting field. Now, we do have to give you a disclaimer that this presentation and webinar should not be construed as legal advice. Obviously, every circumstance is different, so you should always consult with your lawyers, your accountants, your service providers if there's ever an issue. And this is additional background on our firm. I know many of you are clients, so you already are familiar with what we do. But we have been consulting and helping clients in the government contracting sphere for over 25 years, and we provide them a full range of services beyond just regulatory compliance, which is obviously what we will be talking about today, but also corporate work, labor and employment, and litigation. So with that background, let's talk about what we'll be talking about today, which is the new rule on limitations on subcontracting. And although we refer to it that way, the rule itself contains some other changes in SBA's regulations that we do want to touch on, which include identity of interest affiliation, joint ventures, size recertification, size protests, and the non-manufacturer rule. As some of you may already be aware, SBA will be publishing a new rule about the new mentor-protege program for all small businesses, not just 8As, in the next day or two. I mean, what we're hearing is that the rule is at the Federal Register right now, and it's just waiting to be published. When that rule comes out, we will be doing another one of these webinars again to inform everyone what the rule says, and we're going to try to, at the end, if we have time, allowing for questions as well. We're going to touch on what we're hearing is going to be in that new mentor-protege rule, so hopefully you'll get a preview. And that preview is based on a seminar that our firm did with John Klein of the SBA last week. Mr. Klein is the Associate General Counsel in the Office of Government Contracting at the SBA. He's the guy who had a hand in drafting these regulations, and so Katie and I were both present at that seminar, and we will relay things that we learned from him about the limitations on subcontracting rule, as well as the, hopefully, time allowing, the mentor-protege program. Again, the slides are available. We can take questions as we go. Due to the number of attendees, we'll try to answer the questions, but it might not be possible. If we don't answer your question during the session, please feel free to email us separately. So how did we get here? This all started with the 2013 NDAA that revised the Small Business Act to revise essentially the limitations on subcontracting methodology for companies pursuing set-aside contracts. SBA issued its proposed rule back in December 2014 and then issued its final rule just a short time ago that became effective on June 30th. I will tell you that it is SBA's position that because the rule is effective on June 30th, it applies to any solicitations issued after that date. The SBA is aware that obviously the rule has not been incorporated into the FAR yet, and therefore some contracting officers might resist its applicability to that contracting officer and the procurement that they're overseeing. But it is SBA's position that because it's based on statute and because it's based on regulation, any solicitation that's issued after June 30th, 2016 for a set-aside contract should incorporate the new limitations on subcontracting rule. So if you have a proposal pending that you submitted before June 30th, 2016 for a set-aside contract and award has not been made yet, you should find out from the CO which rule applies, old rule or new rule. So let's get down into the nuts and bolts. I'm going to hand the microphone over to Katie, my colleague, and she's going to get into the weeds a little bit on the new limitations on subcontracting rule.
Thank you, Megan. So just to start with the limitations on subcontracting, first we should probably get an overview of what the prior rule was before the new rule went into effect. And if you've been doing government contracting for a while, you're probably familiar with the old construction, which was based on the prime contractor's compliance with the portion or cost of the contract that was incurred by personnel with the prime contractor's own employees. So personnel costs were the key rubric in performing your calculation. And you can kind of understand the difference when in a change in the nomenclature that have come around with this rule. It used to be termed the performance of work requirements, with work being underlined. Now it's that we're trying to shift away from that terminology and call it simply limitations on subcontracting. So we're kind of stepping away a bit from the focus on what work was performed and shifting to the total cost of the contract. And that was the main change that was announced in the 2013 NDAA, was that limitations on subcontracting calculations must be evaluated based on the percentage of the overall award amount that a prime contractor spends on its subcontracts. So, as we were just saying, the concept shifts from focusing on the amount of work performed by the prime contractor's own employees to limiting the overall total contract award percentage that can be spent on subcontractors. In addition to changing the calculation rubric, the NDAA also introduced the concept of similarly situated entities, who are certain subcontractors whose performance will not count as work performed by subcontractors during the limitations on subcontracting calculation. In addition, the new limitation on subcontracting calculations would now apply almost uniformly across all the small and socioeconomic set-aside programs. So that's a shift where we used to see in the rules, and you can probably still see it in the FAR clause, I believe, 52-219-14, separate calculations for 8A contracts, hub zone contracts, SDVOSB contracts. It was the same percentage, but different portions of the rule. All of that has been swept aside in favor of one calculation. So first, we're going to talk what is a similarly situated entity, because that becomes important when you're looking at whether or not the prime contractor is complying with the limitations on subcontracting. So it's work performed. So first of all, work performed by similarly situated entities may count towards the applicable limitations on subcontracting. So what is a similarly situated entity? It's basically any subcontractor that would be otherwise able to prime the contract on its own. It has the same socioeconomic designation as the prime contractor. So if it's an SDV OSB set-aside contract, your subcontractor is also an SDV OSB. A second criteria is that the similarly situated entity has to be small for the NAICS code that the prime contractor has assigned to the subcontractor will perform. And that's a difference in between the proposed rule and the final rule. SBA originally proposed that similarly situated entities had to be small under the NAICS code that the contracting officer assigned to the prime contract. But then I think what they received a couple of comments and they reevaluated it, and they realized that they thought that the subcontractors really only need to be small under the NAICS code. The prime contractor assigns to the subcontract, and this is a new SBA regulation from a couple of years ago. Prime contractors are required to assign a NAICS code to all subcontracts, and that NAICS code has to describe the primary purpose of the subcontract. So this is a very interesting concept actually, because basically, let's say you've got a prime contract that's assigned a NAICS code with a size standard of $15 million. If the prime contractor has a good argument that the NAICS code it assigns to a subcontract is a size standard of $30 million, because that NAICS code best describes the primary purpose of the subcontract, then it can go ahead and assign that NAICS code to the subcontract and count a subcontractor that is also, let's say this is a small business set-aside contract, that is also small under the $30 million size standard for that subcontract. That prime contractor can count the work performed by that subcontractor towards its limitations on subcontracting compliance, even though that subcontractor is not small under the NAICS code assigned to the prime contract. So it's a little bit of a, it's expanding, I think, the concept of who can count towards its limitations on subcontracting. And also, in order to count, the work must be performed by the subcontractor's own employees. And I think we got a question before the webinar started with regard to whether or not 1099s count towards whether if a subcontractor is employing a 1099, or if the prime contractor is employing a 1099, whether or not that can count as a subcontractor employee. Their SBA, I think, is stepping away from that construction a little bit, but 1099s may be counted by a prime contractor as a similarly situated entity if that 1099 or independent consultant meets the other criteria for similarly situated entities. So with that said, the calculations the percentages are essentially the same for all of the various industries. For services contracts, prime contractors are still expected to meet the limitations on subcontracting, that it will not pay more than 50% of the amount paid by the government to the prime to firms that are not similarly situated. So, and for supplies and products other than from a non-manufacturer of such supplies, the prime contractor will not pay more than 50% of the amount paid by the government to the prime to firms that are not similarly situated. And an exclusion for supplies and products is the cost of materials. So cost of materials are excluded and are not considered to be subcontracted when you have a supply or products prime contract.
And I just want to jump in real quick. I see that we're getting a lot of questions about how the prime assigns the NAICS code to the subcontract. First, I want to point out that the SBA acknowledges that there is a potential for a total pass-through here. So if a prime on a services contract is required not to pay out more than 50% to non-similarly situated entities. So in other words, it must retain at least 50% of the contract value and perform that 50%. It is conceivable that as a WOSB, let's say, on a services contract, that WOSB can subcontract out all of its work on a WOSB set-aside contract to a WOSB subcontractor and be in compliance with this new rule. That is conceivable. It's not in violation of the statute. It's not in violation of the regulation. And the SBA's position on this is, why would anyone do that? Well, as you know, a couple of people have pointed out in their questions, if you assign a NAICS code to your subcontractor that has a much larger size standard than your NAICS code, then you could potentially have a much larger similarly situated entity perform this work. That is possible. It's not in violation of the statute or the regulations. So SBA recognizes the loophole, and we'll see what they do. But yes, it is possible that the NAICS code assigned to the prime contract has, let's say, a $15 million size standard. And yes, it is possible that as the prime contractor, you assign a NAICS code to your subcontractor that has a, let's say, 500 employee size standard. As long as that subcontractor is small, under 500 employees, and you are small, under 15 million, you are all in compliance with limitations on subcontracting. There is a check in the system. The NAICS code that you as the prime contractor assign to your subcontract should match the principal purpose of that subcontract. And it is possible for the subcontractor's size to be protested. That's in the current regulations. That's not new. A subcontractor size can be protested. So it is possible, and I think that that's how SBA would see that, just like now for primes, it's a self-regulating system, and I think that SBA assumes the same.
And just to quickly jump in on that point too, it's possible to protest the size of a subcontractor. It's fairly difficult. The way the regulation is set up now, it's either the contracting officer can initiate a protest of a subcontractor, the prime contractor itself, although I don't know why a prime contractor would ever protest the size of its own subcontractor, but that's the way the regulation is set up, or the SBA. So if you are a competitor and you think that some shenanigans are going on, it would be very hard for you to lodge a protest of such an arrangement unless you directly lobby the contracting officer or the SBA itself to take up your grounds for protest on their own. So that's just a quick point to make. And also, this was another question that we had from John to John during our seminar last week, which Megan and I thought was a good one. For WOSB set-asides, John clarified that it's not the SBA's position at this time that the NAICS code that you assign to the subcontract has to be a WOSB or EDWOSB NAICS code in order to count as a similarly situated entity. So just that's a quick point about WOSB prime contracts. So slide 10, you can see the new rules on supplies from a non-manufacturer, where waivers and waivers have not been granted and waivers have been granted. Skipping ahead to the percentages for general construction and special trade contractors, you'll see that those percentages are the same as they were before, so no more than 85% of the amount paid by the government to the prime may be paid to subcontractors that are not similarly situated for general construction, and that figure is 75% for specialty trade contractors. And cost of materials are excluded from both of those calculations.
So just two quick notes. First, cost of materials includes your subcontractor's materials. We're going to get to a diagram in just a couple slides when we're actually talking about these mixed contracts on how to calculate that. So I just want to, materials is for the entire prime contract, which shouldn't, by its nature, include your subcontractor's materials as well. The other quick note that we wanted to raise is that for any companies out there that are in environmental remediation, those are services NAICS codes, not construction. And so we know, we've already been hearing from the industry that the new rule could have a severe impact on them. That if it's no longer a labor-based calculation, and we actually did lobby SBA during the rulemaking process to point out how the new rule and the new methodology could severely impact environmental remediation companies. We have already talked to John Klein about that. We want him and the SBA to reconsider this, and he is open to receiving a letter or a white paper from us and from industry. So if you are an environmental remediation company, if you are interested in having this changed, then please get into contact with us, because we would like to help industry submit something to the SBA to point out why this is not going to work. So, mixed contracts. When we're talking about mixed contracts, we're talking about contracts that contain both services and supplies. So what do you do then? Which rule applies when you're dealing with a mixed contract? The answer is it has to be one or the other. You don't have to comply with both. You pick, the CO picks one or the other, and that's what you have to comply with. So the responsibility lies squarely on the shoulders of the contracting officer to assign the appropriate NAICS code to the mixed contract. That NAICS code would either be a services contract, in which case the services limitation on subcontracting applies, or it would be a supplies NAICS code, in which case the supplies methodology applies. So we provided here in this next slide the example that comes directly from the regulations. And then we've also diagrammed it to show you how this would kind of break down when you're actually crunching the numbers. So in our SBA's example, I shouldn't try to take credit for it. In SBA's example, the total contract value is $3 million. Of that $3 million, so the supply portion is $2.5 million. Because that is by and large clearly the principal purpose of the contract, the CO assigns a manufacturing or supplies NAICS code to the prime contract. So the prime contractor now must comply with the limitations on subcontracting supply percentage. So of the supply portion of the contract, $2.5 million, the prime contractor cannot pay out more than 50% to non-similarly situated subcontractors. So we look at that $2.5 million supply portion. There's also materials in this example, so we deduct the cost of materials in this supplies contract, which leaves us with $2 million as a straight up supply portion. Again, the prime cannot pay out more than $2 million to non-similarly situated subcontractors. Katie and I have spent hours.
That's not an exaggeration.
We have spent hours discussing what cost of materials means. This is how we like to spend our free time, and how it comes into play on a services contract, which we'll look at in just a second. But this diagram deals with the supply contract. So first, we focus on which portion of the contract is supplies, and then from that portion, what can we take out for materials, and then we determine our calculation.
And just real quick, so you see that the two bullets, supply $2.5 million, services $500,000. When you're doing your limitations on subcontracting calculation for the contract, you don't take into account the services portion. Just do what you want with the services portion. Because this is a supply contract, focus exclusively on that $2.5 million. You're not running two calculations for one contract. It's just you see what the primary purpose of the contract is, zero in on that portion of the contract that is applicable to that NAICS code.
And I know we saw a question earlier on who lobbied for this change. This was implemented in the NDAA because Congress thought that this would be an easier way for contractors to calculate this. And what you're seeing now is the written example from the regulations of a mixed contract, and moving forward to the diagram. Congress and the SBA thought that basing the calculation over the total value of the contract, and then more specifically on the portion of the contract to which the limitation on subcontracting applies, was an easier calculation, because as a prime you are not always privy to the buildup of your sub's pricing. So you would have to some degree take a well-reasoned guess as to whether you truly were in compliance or not. This methodology, the intent of it is to make it easier. So let's look at example 2. Again, we're dealing with a $3 million total value. Of that $3 million, 2.5 comprises the services portion. Therefore, the CO has assigned a services NAICS code to the contract, and the services limitations on subcontracting methodology applies. So just as, Katie's very important point on the last diagram still applies here. You are only charged with complying with limitations on subcontracting to, in this example, the services portion, because that's the principal purpose, the thrust of the contract. So $2.5 million is your basis of calculation. As the prime, you cannot pay out more than 50% of $2.5 million to a non-similarly situated subcontractor. But you and your similarly situated subcontractors can receive that half of that amount or more. I mean, at least 50% must go to you or similarly situated subcontractors. And again, the similarly situated subcontractors are, for an 8A, it would be an 8A firm. For a WOSB, it would be a WOSB firm. For a hub zone, it would be a hub zone. For an SDVOSB, frankly, this is not a change for SDVOSBs. They have been allowed to comply with their limitations on subcontracting requirements in this very exact way for the past few years.
Hub zones too.
Hub zones too.
So a question you might have is, okay, we hope at least, we understand the limitations on subcontracting. We understand how the calculations are supposed to be performed. How am I supposed to determine compliance? What periods of time am I thinking about? And I know sometimes people like to say, oh, think about the life of the contract. That's not technically correct. For total or partial set-aside contracts, you really have to think about it on the basis of the ordering terms. So it's either the base, so you can think about it, you have to comply during the base term, and then for each subsequent option period, you need to comply with the overall limitations on subcontracting. So it's not, quote unquote, over the life of the contract. So that's for total or partial set-aside contracts. For orders that are set aside under a full and open contract with a reserved, you have to comply for each period of performance for the order itself. And that makes sense too, because the contract itself wasn't set aside. So because the order has specifically been set aside, then you have to comply for that specific order. And you can think about that on, like, for example, with regard to GSA schedules. Let's say you receive a small business set-aside order under your professional services schedule. Because the PSS schedule hasn't been completely set aside for small businesses, and that order was, then you have to comply with the limitations on subcontracting for that specific order. And also keep in mind, for some of your larger vehicles, contracting officers, they most definitely maintain the discretion to require compliance with your limitations on subcontractor on an order-by-order basis. I mean, I think we get a little sometimes lost in these regulations because they're SBA regulations, and SBA is ostensibly the one that's supposed to be enforcing them, but limitations on subcontracting are terms and conditions incorporated directly into your contracts. So that is a contractual term that you have entered into with the agency itself. So contracting officers, they're supposed to be monitoring your compliance with these things. So if the contracting officer says comply with the limitations on subcontracting for this order, you're bound to do it. Compliance is an element of responsibility, and it's not going to be looked at in a size determination. So if your size is protested for a particular set-aside contract and you're responding to the size determination, you don't have to prove that you'll be in compliance with the limitations on subcontracting. However, another thing to keep in mind, like I was just talking about before, your compliance with limitations on subcontracting will be reflected in your overall contractual performance, like your past performance evaluations. Contracting officers are allowed to take it into consideration when they're evaluating you on future procurements. So it's definitely a matter of responsibility, and will go into your permanent record, so to speak. And just another quick note, I think we mentioned this off the top, but independent contractors can now be considered subcontractors and can count towards meeting your limitations on subcontracting requirements when the independent contractor independently qualifies as a similarly situated entity.
And just real quick, as we go to the next slide, I just want to take a step back and point out what are some of the terms or changes you need to make in your current teaming agreements and subcontracts when you're pursuing prime contracts that are set aside. So one change that you might want to consider making immediately is if you don't already have a provision in there that assigns your subcontract a NAICS code, you want to add that. You want to add a NAICS code provision. You want to also add a requirement that they represent to you what their size and status is. Under SBA's regulations, you as the prime are 100% allowed to rely on their SAM representations. But for extra coverage, it would be prudent to have them make an affirmative representation to you on top of that. So have them make a representation in their team agreement and in their subcontract. And then the very last provision that if you don't already have it in your templates that you might want to add is a requirement that everyone's aware of the limitations of subcontracting rules, that they apply to the prime, contractor, and therefore everyone will comply with it to the extent it is applicable to them. That way, for instance, if your subcontractor is a non-similarly situated entity, i.e. a large business, they will be put on notice that there's only so much work that you can give them before you need to make sure you're in compliance with the rule. Katie, do you have anything else that you would add to that list?
So I would say that it's a general construction in small business law that size is determined as the date you submit your proposal to the government. That's if your size is protested on your prime contract, that's when the date your size is determined. There's really no corresponding rule in the regulations with regard to when subcontractor size will be determined. I think a good rule of thumb is when they submit their subcontracting proposal to you, the prime, that should be the date that you determine whether or not they're a small business. So just like what Megan said, when they're supplying to you that representation that yes, we are small, that should be the date that you rely upon. Another thing, I mean, because because there's really no flow down, I think, for subcontractors. I mean, I think John said at the seminar last week that you can almost rely upon the way that the size rules work, the timings for the size rules work for for prime contractors that you can for subs. So if your subcontractor was small when it represented that it was small when it submitted its proposal to you for the contract, then you should be able to rely upon that representation, and it should work the same way as a prime contractor small business representation worked when it submitted its proposal. So just real quick, limitations on subcontracting do not apply for small business set-aside contracts between the micro purchase threshold and the simplified acquisition threshold. And they also don't apply to subcontractors entering into lower tier subcontracts, except where the prime is relying on the subcontractor's similarly situated status. So basically, the rule is right now that prime contractors can only rely on their first tier subcontractors for to meet the similarly situated requirement. So you can't rely on representations made by second tier subcontractors to meet the limitations on subcontracting for the contract.
And we're asking for people to clarify this last bullet. So what this is basically saying is that when a small business subcontracts with a large business, that large business can then subcontract with anyone. It doesn't count one way or the other, similarly situated or not. When a small business subcontracts with a similarly situated entity, which for that small business would be a small business, then that small business counts towards the prime's 50%, But then there's also a limit on how much that small business sub can then pay out. Because again, it's the total value of the contract. So you cannot pay out more than 50% on a services contract to a non-similarly situated entity. So if Katie is the prime, we're both small businesses, Katie subs to me, I'm a small business, and then I go and sub to a large business, that large business lower tier subcontractor must be within the less than 50% on a services contract.
Right. SBA is trying to avoid the situation where you're using this rule as a total pass-through to large businesses.
And just one more clarification on the similarly situated. It has to be the exact same as the prime level. 8A to 8A, small to small, WOSB to WOSB, EDWOSB to EDWOSB. So no, I saw a question earlier. An 8A firm could not subcontract to an EDWOSB and count that as a similarly situated entity because it's an 8A set aside. So we're segueing out of the limitations on subcontracting, and we're going to touch on some of the other issues.
Right. We saw we had a lot of questions with regard for limitation on subcontracting. We'll try to hit them up at the end of the program, but if we can't get to them, then we'll definitely email you answers because we know that this is confusing stuff. So really quickly, identity of interest. So the SBA included some changes to the identity of interest affiliation rule. Affiliation, I'm sure if you're small businesses, you're generally aware of this concept. It's when SBA is determining your size, whether you need to count the size of your sister companies, subsidiaries, parents, or another company that you just enter into a lot of business with or you have contacts with. So it's what do you count towards your own small business size when you have feelers or tentacles out in other companies. So SBA has revised its definition on familial relationships. It gives a little bit more clarity on what types of familial relationships will give rise to a presumption of affiliation between companies. So the rule clarifies that there will be a presumption of affiliation between companies that are owned by married couples, so like a husband and his wife's company would be deemed affiliated, parties to a civil union, parents, children, and siblings. So all of these immediate familial relationships will be presumed to be affiliated with each other if those companies conduct business with one another. So for example, if you have a subcontract, if your husband's company has a subcontract with your company, or two siblings work out of the same facility and share back office support, those two companies might be deemed affiliated. The type of business connections we're concerned with here are subcontracts, joint ventures, or sharing or providing loads, resources, equipment, locations, or employees with one another, especially sharing employees. I feel like that is a very strong indication of affiliation. But this is a rebuttable presumption. So if you feel like, for whatever reason you're on floor 1 of an office building and your brother's company's on floor 10, but you haven't spoken to your brother in 10 years and you have no other ties between the companies, that it's rebuttable. You can demonstrate that there's a clear line of fracture between those two companies and that you haven't engaged in the type of business practices outlined in the bullet above, and you can show that those two companies operate completely independently of one another and therefore should not be counted together. The SBA also clarified its definition of what economic dependence affiliation consists of. So the SBA's Office of Hearings and Appeals had adopted what's been known as the 70% rule in a line of cases, and so this new regulation essentially codifies OHA's prior position. So essentially it says that if a firm derives 70% or more of its revenue from another firm over the previous 3 fiscal years, SBA will presume that the one firm is economically dependent on the other, and therefore that the two firms are affiliated. So it's sort of, if you're, a new company, for example, and you've got one major contract or two major contracts, and one is really large, and you're like, oh, well, am I automatically affiliated with that company that gave me my initial contract? That doesn't seem fair. And no, that's not the case. It's a rebuttable presumption again. And you must show that despite the contractual relations with the other concern, that you are not solely dependent on that other concern for all of your revenues. So startups shouldn't be penalized. An example that I think that John Klein uses at the seminars all the time is if you're limited by your geographic considerations, like you're operating in a very small town and there's really only one other company there that you do business with, you shouldn't be penalized for that either.
Someone did ask a question about how you show a clear line of fracture. With a familial relationship, what we would do is show to the SBA in a declaration potentially that if my brother and I were in the same line of business, maybe we had one subcontract with one another, but that was many years ago, then we would both complete declarations that would say it was one subcontract many years ago. We don't talk shop. We don't plan to do business with, we don't have any current business with one another, and we don't plan to do business with one another in the future. We've received a number of questions about joint ventures in the limitations on subcontracting, how that applies to joint ventures. Well, this rule also updated the regs in a small respect for joint ventures, and what it provides is, under the prior rule, you all might be aware that there is an exception for affiliation for two small businesses to form a joint venture dependent on the size of the contract, the dollar value of it, whether it was bundled, whether it was consolidated, and it was frankly pretty confusing. That's all eliminated. All that matters now is two small businesses can joint venture with one another and be deemed to be exempt from affiliation with one another so long as they are each small under the NAICS code assigned to the prime contract the JV is pursuing. So this now is giving small businesses a lot more flexibility to enter into joint ventures with other small businesses. This second bullet, or second major bullet, is pretty important, and I think a lot of questions that we've received so far have touched on this exact issue. Similarly situated subcontractors are excluded from affiliation under the ostensible subcontractor rule. That means, going back to a services contract, if I'm the prime and I cannot pay out more than 50% and I get another like business, another similarly situated subcontractor, I can have that sub perform my 50% and we will not be affiliated because under this change they are excluded from the ostensible subcontractor rule, even if that similarly situated subcontractor performs the primary and vital tasks of the prime contract. We're just going to fly through the next couple of slides that are just updates to the regs. The size recertification change is the more major of the two. And this new size recertification rule requires recertification of size after a merger or acquisition for a firm that submitted an offer as a small business concern. So under the current rules, recertification was only required if you already had a set-aside contract. You were already performing the set-aside contract. Now, SBA is saying if you undergo a merger or acquisition before award and you have proposals pending for a set-aside contract, you need to go tell the agency and recertify your size as either small or other than small based on the merger or acquisition. This is a pretty big change. It received a lot of pushback during our seminar with John Klein last week, and John stood firm. He is of the opinion that, and SBA is too, presumably, that they do not want small businesses to submit proposals, then be acquired by a large business, and the large business would reap the benefit of that set-aside award. That's what they're trying to prevent. Now, when you recertify, you are likely, depending if you are certifying as other than small, you are likely no longer eligible for award. If you already have a contract and you recertify on a set-aside contract, you can still keep the contract. The regulations don't require the procuring agency to immediately terminate the contract. What the regulations say instead is that the procuring agency can no longer take small business credit for your work and the payments that they make to you. Just very quickly, the size protest is just a clarification that essentially certain persons at SBA can file eligibility protests, and then also an offeror who is technically unacceptable does not have standing to file a size protest. This is just a clarification issue. So now we're getting to Katie's favorite topic, which is the non-manufacturer rule. For those of you out there who are not in manufacturing and never have to deal with compliance with this rule, you should be very grateful, because it's not the easiest rule to understand, but it is a a limitations on subcontracting requirement.
Exactly. I know Megan is speaking in jest. But this final rule also did provide some clarifications on the non-manufacturing rule. That's NMR here, and LOS is limitations on subcontracting. So the SBA clarified that limitations on subcontracting in the non-manufacturing rule do not apply to small business set-aside contracts valued between the micro purchase and simplified acquisition thresholds. So I think we had mentioned that before with limitations on subcontracting, but it's also true for non-manufacturing rule as well. And then with regard to waivers of the non-manufacturing rule, SBA added language in 121.1206, which require contracting officers to notify potential offerors of any waivers, whether class waivers or contract-specific waivers, that will be applied to the procurement during the procurement process. And the waiver of the notification of the application of waiver must be contained in the solicitation. And the final rule also authorizes SBA to grant a waiver to the non-manufacturing rule for an individual contract after a solicitation has been issued, provided that the contracting officer agrees to provide potential offerors additional time to respond. So essentially it's just giving the contracting officer a little bit more, or formalizing, I think, maybe a standard practice up to this point, that the contracting officer has a little bit more leeway to deal with waivers and waiver applications, and to kind of midstream before proposals are due, but after the solicitation has been issued, that they can accept those waiver requests as long as they give everyone a little bit of extra time to respond to the solicitation.
So before we get into questions, I just want to take maybe 2 minutes to summarize what we learned from John Klein last week in our seminar about what to expect in the new mentor-protege rule. Again, we expect that to be published by Federal Register any day now. The SBA in the new mentor-protege rule is making the 8A and the new small business mentor-protege program as similar as possible. So what that means is that the SBA is not just expanding the program for small businesses of all types, WOSB, SDVOSB, HubZone, etc. They are also changing slightly the current 8A mentor-protege program. The periods, for example, the periods for which an 8A could get a mentor is being eliminated. Under the new rule, a small business or an 8A can have a mentor under a secondary NAICS code. So if you're not limited to just your primary NAICS code, which is what was in the proposed rule, they've stepped away from that. You are allowed to have a mentor in your secondary NAICS code. The SBA is capping the number of relationships you can have. Over the life of the company, for right now, in the new rule, it's going to be two. Two total mentor-protege relationships.
One more time, Megan.
Two. Not to be confused with the term that SBA is allowing. So each mentor-protege relationship that you have can have essentially a 3-year base with the option to extend for another 3 years. So in total, your mentor-protege relationship can last 6 years under the new rule. And then as far as joint ventures are concerned, I think this has been getting a lot of attention. I know I've received a lot of questions about this. Yes, the SBA is phasing out populated joint ventures for set-aside contracts. The SBA's reasoning is that when, let's say an 8A protege and its mentor form a populated joint venture under the current scheme, and they're performing a services contract, the employees that are populated in that joint venture tend to come from the mentor, from the large business. So after contract performance, when the 8A firm is left to say, okay, what did the 8A firm gain from this joint venture? They say, well, we gained all this experience. The SBA will say, okay, who are the employees with that experience? Well, the employees of the joint venture went back to work for the mentor. So in truth, the 8A, besides having something else to put on their corporate capabilities, hasn't gained true hands-on experience because its employees were not the ones who were performing, and the SBA wants to avoid that. So they are moving away from populated joint ventures to unpopulated joint ventures, or joint ventures that are populated only with administrative personnel. This creates a tension for those of us who are in performing on cleared contracts, because an entity, in order to receive a facility clearance, has to have personnel, because the entity's clearance is based on the clearances of its key management personnel. So one way to kind of get around this potential issue for an unpopulated joint venture is to populate that joint venture with administrative personnel, i.e. key management personnel who hold the necessary clearance. So for instance, for the majority owner or one of the members of the joint venture who already has the clearance the joint venture will need to perform, one of the managers or key management personnel of that entity of the member, like the FSO, the facility security officer, can split his or her time between his current employer and then the joint venture. And that way the joint venture would rely on the FSO in order to get its facility clearance. So be on the lookout for the new mentor-protege rule. We will be doing an announcement as soon as we see it and review it with our analysis. We'll be doing another one of these webinars to summarize it for everyone. So Katie, what kind of questions, a populated joint venture versus an unpopulated, it speaks to employees. So a joint venture that has its own employees is referred to as a populated joint venture. An unpopulated joint venture generally doesn't have any of its own employees.
So I think, Megan, I was reviewing the questions while Megan was giving you the overview of the mentor-protege program, and we have a little time. I think something that we can discuss that people were asking a few questions about is when you're doing supplies for services for the mixed contracts, cost of materials, and if you're looking at a services portion of the contract, what do you exclude for cost of materials for services? This seems to be a question, and as Megan mentioned before, we've talked internally about this quite a bit. We can give you our thinking on it.
So we've looked at it a couple ways. First of all, it is the SBA's position that cost of materials was never a consideration in a services contract calculation before, and it shouldn't necessarily be a consideration in a services contract now. With that said, any cost on a contract that has a services NAICS code, any non-services cost should not be part of the basis of your calculation. Well, and so I know you're going to ask me, how do I know if something is part of my services cost? It is all dependent on, our perspective is, it's all dependent on how you break down your price in your price proposal. How you break down the labor and how you break down the materials you will be using and how you will break down supplies, if any, that you will be providing. Your ODCs, for instance. I would imagine that sometimes that would be contain the materials that you would use. And so we want to have the price breakdown. And then from there, when you can portion out the services portion, that becomes the basis of your calculation. With the caveat that under the new regulation, the services portion upon which you based your calculation must include G&A and overhead. So if your materials are baked into your G&A and overhead, for instance, Katie and I like to use a janitorial services contract as an example. If you're a janitorial services provider, you service 10 different government buildings, and you have vendors that provide you cleaning supplies and toilet paper. And you have the same vendor for all 10 buildings, so that's wrapped up in your G&A and overhead. That would be part of your services calculation, even though, yes, it is a material, because it's wrapped up in your G&A and overhead. But if that's a separate line item in your price breakdown on your contract, and you can squarely show how it is a separate supply and or material under the contract, then you should deduct that out and focus only on the services portion. Did I say anything wrong, Katie?
No, that took us, that was hours of discussion where what Megan just told you, that's where we landed. I think that's correct. So you really need, so the preamble to the rule is very clear. Overhead and G&A must be wrapped up into your services component. We kind of just wish that they put an exclusion for cost of materials into the services calculation. They haven't, and they were very clear that they're not going to. So you really have to approach it the way that Megan just outlined. Basically, anything that's not services, when you run through the way that you broke down your price in your proposal, take that out, because you really are supposed to only be focusing in on the services component of the work. So hopefully that's helpful.
And just to touch on very quickly, in the supplies calculation, you can deduct a cost of material. So a question we often receive is, what's the difference between a supply and a material? And one way to think about it is a supply is often tied to a CLIN. So it's an end item that's being delivered to the government. A material can be a component of that supply. So let's say you're delivering a widget to the government. The widget is your supply, and let's say that widget is battery powered. So in order for you to deliver a functioning widget to the government, you have to put a battery in it. The battery is a material. So when you're doing your calculation under a supply, limitations on subcontracting methodology, you deduct the cost of that battery from the total cost of the widget, and then whatever is remaining is what you base your calculation on.
Another item that appears multiple times in the questions is, how do you assign the NAICS code to a subcontract? And is that a requirement now going forward, even for small business prime contractors? The answer is yes. You are supposed to be assigning NAICS codes to all of your subcontracts. That is a requirement for large businesses as well, but it also is for small businesses. And as we were discussing before, it should function very similarly to the regulations instructing agencies and contracting officers how they're supposed to pick the NAICS code that are assigned to the contract. And it's really whatever is the primary purpose of the work that's going to be performed. So I imagine as this new similarly situated entity rule picks up steam and we see it in practical application, I very, very strongly suspect that SBA is going to amend their regulations again to provide more instruction on how NAICS codes are supposed to be assigned, and also to allow, I think, protests of the NAICS code selection of the subcontracts, in addition to opening up the door, I think, to protesting subcontractors' size. I mean, expanding. The door is already open, expanding the door, I think, to allow competitors to protest the size of a prime contractor subcontractor. But right now, with regard to the similar situated entity rule, the NAICS code that you choose and that you select for the subcontract is very important.
There's an interesting question about CTAs, and I don't think you and I have ever talked about that, but how do you think this new rule going forward would impact CTAs for GSA schedule contracts?
So I think GSA schedule contracts, the way I've always viewed CTAs in that context is that CTAs are very much, in a GSA schedule context, an association between two prime contractors. So I believe that it's going to be the same as it was before, in that all CTA members have to meet the set-aside requirements for the order. So if it's a small business set-aside order with a $15 million size standard, even if you're the team lead, you can't assign a subcontract and shoehorn in a team member with a larger size standard. I don't think that's going to work. I think CTAs for schedules are very specific. Now we've seen CTAs in a broader sphere, a broader context lately. I know SBA has a distaste for them because it's a very weird relationship, I think. Is it a prime sub relationship? Is it a joint venture? It's really not very clear. So I think generally I think CTAs outside of a GSA schedule context, we're going to see it more fashioned along the line of prime sub relationship. So you might see a prime assigning a NAICS code to a subcontract in that context.
And then we have a bunch of questions about the effectiveness of this new rule. Let's say if you have a GWAC and you're pursuing orders under that GWAC, or if you have a GSA schedule, how does this apply? So the simple answer, the lawyer's favorite answer, is it depends. So what I would say is that whatever's on that master contract, and I'm going to use that term very broadly to encompass your GWAC, your IDIQ, your GSA schedule, whatever the limitation on subcontracting requirement is in your master contract controls, except if in a task order the procuring agency CO incorporates a different, i.e. the new limitation on subcontracting requirement. So we're in kind of a gray area right now. If you're pursuing task orders and you have potentially the ability to look at, are you better under the old calculation or the new calculation for the work you're pursuing on that task order? If it's the new methodology, you think you could attract maybe better subcontractors, giving them, you think that there's an ability for you to give them a greater piece of the pie. Under the new methodology, then it would be in your interest to raise this for the CO during either the Q&A process or any time during clarifications, so that it's on the CO's radar that yes, we want the new rule to apply to the task order that we are going to award. If you already have an awarded task order that you're performing, you already have a contract that's awarded and you are performing, the old rule applies, unless the CO takes affirmative steps to incorporate the new rule.
And I think that's important. I know we're getting short on time here, but I think it's very important. We're going to need to have a lot of back and forth with the agencies because the FAR has not been updated yet with these new rules. So the limitations on subcontracting FAR clause 52-219-14 hasn't changed. And that's what gets incorporated into your contracts. However, the statute is on the books. The SBA's rules are in effect. So you really need to push the contracting officers on this point during the questions and answers and have it somewhere in the contract very clear, or the solicitation ideally, very clearly explain what's going to happen for this contract and what is going to be applied.
Are there any other questions that you think? We still have so many people that are still present, so we want to try to hit a lot of these as best we can before we close out. Let me see. A lot about the
effective date.
Yeah, the effective date, and I hope that that last answer helped with that. Here's a HubZone question for you about the proposal deadline and versus the award date.
Oh, it would be, yes. HubZone, you still need to comply on both proposal submission date and award date. So you're right, so that you have to meet the eligibility requirements on both dates if you're HubZone. Doesn't matter if you're prime or sub.
We had a couple of questions about 8As, about 8A joint ventures and then different types of 8As. So for an 8A joint venture, and I think I said this already, but just to make sure we're all on the same page, for an 8A joint venture that's performing a prime contract, a similarly situated entity to that 8A joint venture is an 8A. And then when we say 8A, we mean any 8A. It can be an A and C 8A. It can be an 8A based on an individual status. It can be any 8A. as long as you are an SBA certified 8A firm.
And I did see a question with regard to independent contractors and said, how can a 1099 qualify as a similarly situated entity for an 8A company? Short answer, it can't. I mean, unless it's been, that individual has been certified on his own as an 8A contractor, that 1099 couldn't. I'm really thinking with regard to 1099s that you can use them for small business set-asides, because obviously that individual would be under a size standard.
Yes, a small business prime contractor can count any type of small business. So a small business prime, a WOSB is still, at its very basics, a small business. So yes, you can have a WOSB as your similarly situated prime in that you would count them as a small business sub. And I think we've hit. For anyone who's still on, who is in environmental remediation, is interested in pushing SBA on this issue, our emails are on the screen. Please feel free. I know a couple of you have already dropped your contact information in the questions. Please feel free to email us. And frankly, anyone else, if we haven't touched on an issue, we'll try to get to your questions. But if you have any other questions or follow-up questions, please feel free to email either one of us. You could call us, 202-857-1000. And I think that's it for me.
That's it for me too.
Thank you all so much for attending. We hope that this was helpful, and we will be in touch.